Welcome to The Explainer. We've all had those questions pop into our heads at work. Like, could you actually be fired for one mistake? Or can your boss really make you work all weekend for no extra pay? Well, these aren't just random thoughts. They're governed by a whole world of labor law. And today, we're going to untangle it all so you can know you're right.
Okay, let's dive into this. We're going to explore this often confusing world by looking at some real-life situations. We'll check out actual court cases and rulings to see how these big ideas actually work on the ground. By the time we're done, you're going to have a way clearer picture of the rules that really shape our lives at work.
All right, we've got this broken down into 5 main parts. We'll start with what even sparks a workplace conflict in the first place, then get into the tough stuff like termination, and we'll finish up with the absolute fundamental rights that no one can take away. Let's get right into it.
So, first things first. What exactly turns a simple disagreement at work into a full-blown industrial dispute that the law has to get involved in? Let's take a look.
Okay, picture this. There's a doctor who works on a big tea estate, providing medical care to all the workers there. One day, he's fired. And the workers, they're not happy about it. They demand he be brought back. Now, your first thought might be, hold on, that's between the doctor and his boss, right? What does it have to do with the workers? Well, you might be surprised. The law sees it a bit differently.
So the legal definition here is actually super broad, and you've got to pay attention to that word, any. It's not just about a dispute over your personal contract. It can be about the conditions of labor for anybody, especially if it affects the whole group. And a shared benefit, like a company doctor, that absolutely counts.
And that's exactly why the answer here is a big, clear yes. Because having that doctor on site was a part of their working conditions. It was part of the deal. The protest to get him back is a totally valid, legally recognized industrial dispute. It directly impacts their well-being at work.
Okay, now that we know what a dispute is, let's talk about one of the most serious issues you can face at work, losing your job. And trust me, the way you lose your job is incredibly important in the eyes of the law.
All right, so let me introduce you to Murugan. He gets a job as a bank clerk, and when he's hired, they're very clear. You have 1 year to pass this test to be fully confirmed in the role. Well, the year passes, he fails the test, and he's let go. But then he asks for something called retrenchment compensation. The big question is, should he get it?
To figure that out, you have to know that the law draws a really bright line between 2 ways of losing your job. Retrenchment is when the company lets you go for their own reasons. Maybe your job isn't needed anymore. But termination for cause? That's when you don't meet a clear condition of your employment. The rules are different for a reason, to be fair to everyone.
And that's the bottom line for Murugan's case. Since he didn't meet a condition he knew about from day one, passing that test, it's not a retrenchment. It's a termination for cause. So in this situation, no, he's not entitled to that compensation.
Okay, let's try another one. Imagine your company is doing layoffs, but they offer you a pretty similar job at another one of their offices. Except it's 12 kilometers away. I mean, it's still a job, right? But do you have to take it? What does the law say?
This is where the law gets really practical. It actually sets a specific distance limit. And since 12 kilometers is more than the roughly 8-kilometer limit, it's considered too far to be a reasonable alternative. So you could actually say no thanks to that offer and still get your layoff compensation. Pretty specific, right?
Okay, let's shift gears and talk about strength in numbers. One employee alone might not have a lot of power to make change, but when people get organized, that's a whole different story. So let's dive into the world of trade unions and some of their very specific rules.
So, let's say a group of 12 workers decides they want to form a union. The minimum number you need is 7, so they're totally in the clear. They get all the paperwork together and send in their application.
But then, before everything is made official, 6 of them, exactly half the group, decide to back out. They withdraw their names from the application. So is that it? Is the whole thing over before it even started?
Well, this is where you see just how precise the law can be. The rule says an application is only invalid if the number of people who back out exceeds half. Since it was exactly half, not more than half, the registration actually has to proceed. This isn't just a random detail. It's there to make sure a new union isn't easily broken up by just a little bit of pressure.
All right, we're now moving into a really serious area. What happens when a worker gets hurt, or even worse, dies, in connection with their job? It's a tough topic, but it's so important to know who is held responsible. This table really shows the 2 sides of the coin. Look at worker A. Even though he had a pre-existing condition, the stress of the job on the company's property created a link. The law says the accident arose out of employment, so the employer is liable. But now look at worker B. This is the big exception. If an accident happens while you are willfully under the influence, the law says the employer's responsibility is wiped away, even if you were on the clock.
And for our final section, we're getting down to the bedrock. These are the absolute non-negotiable rights that every employee has. They're the foundation of what it means to have a fair workplace.
So there was this case where a company, Crown Aluminum Works, basically went to court and said, look, we just can't afford to pay the minimum wage. And the court's response was incredibly powerful and basically set the standard for workers' rights in this area.
And here it is, the huge takeaway from that case. When it comes to minimum wage, it doesn't matter if the company says it can't afford it. That's irrelevant. The law sees paying a minimum wage as the basic cost of doing business. If you can't pay it, you don't get to be an employer. Simple as that.
Okay, last one. What about a bonus? Can your boss just decide not to give you one because they think you have a bad attitude? Nope. The law is super specific here too. There is a very, very short list of reasons an employer can legally deny you a bonus. And as you can see, things like fraud or theft are on the list, but something vague like insubordination is not.
So, as we've seen from all these cases, the law isn't just a bunch of abstract rules. It's a framework, a real structure, designed to create some balance and fairness at work. But, the laws are just the starting point. Which leaves us with a final question to think about. What does real fairness at your job look like to you? And how do we all work to make that a reality?